Hello friends, my name is Dr. Jigisha Singh, and in this video I am going to introduce you to some basic concepts of the Indian Contract Act. The core legislation that I would be discussing in this lecture is the Indian Contract Act. It is a statute that has been enacted in the year 1872 and, as already told, is called the Indian Contract Act. If we look into the bare act, we will realize that the entire act is divided into chapters, and chapters are divided into sections, and sections are divided into clauses. So, statute, chapter, section, clauses. Now, it is important for us to understand that in our daily lives we undergo and enter into various contracts, be it contract of retail shopping, you are buying a chocolate, you are buying an ice cream, you are hiring any services, be it a contract for job, be it a contract for hiring any services like in hospitals or teaching educational institutions. So all of this is contract. So uh, we are within that very umbrella, within that very sphere whereby we enter into contract daily. Now, for example, I will have to understand, I will have to tell you that the Indian Contract Act, how does the contract actually come into being? What is that stage which is called as the starting point of the contract, and what is that stage that reaches up to the contract? That is what it has to be seen. Now, for example, in case a person A wants to purchase books from B, the first thing A would do is to approach B that under certain conditions A is willing to buy books from B. Now A approaches B, that is, A is making an offer. So for a contract, generally speaking, the starting point is making an offer. It is the making of an offer by the first person to another person. A person who makes the offer is called the offerer, and the person to whom the offer is made is called an acceptor, because offer is made to him for an acceptance. Now, for the contract, at least two persons are essential who are known as offerer and acceptor. Now, as I have already told, that generally speaking, the starting point of the contract is offer, but in certain circumstances, the starting point of an contract is invitation to making an offer. Now, this is the acceptor actually who invites applications, who invites offers from the offerer, and whatever offer is suitable to him, he can go along with that. So, such a person who is inviting to make an offer may be called as the acceptor, and the one who responds to the invitation are offerer. For example, Faculty of Law is inviting applications, so they are the acceptor, and the persons who are filing the necessary forms are the offerer. Now, there are various terminologies that are being used for offerer and acceptor. In the Bare Act, we call it as a promisor and promisee respectively. We can also say it as proposer, proposee. So I would be using these terms interchangeably. Now, as far as the Indian law is concerned, it came into being from the English law, which is the common law of United Kingdom. It is based on UK law, but Indian law is codified. Now, law of contract of UK is entirely a judge-made law, a precedent and not a statute contained in the common law. Whole branch of civil law is a precedent. Law made is perfect as it is logical, and one which is logical is immortal. Now, when an offer is made, there must be communication of the offer. That means you cannot keep your offer in the mind. There has to be an external manifestation of the offer to the other person. That means it must be communicated to the person concerned. The word that is used for communication in the statute, in the act under section 2A of the Indian Contract Act is signify. So both the offer and the acceptance has to be signified. Now, it has to be communicated. Now, communication is possible by two methods, either direct or indirect. In direct communication, physical presence is a must. Now, for example, a professor gives lecture in the class to the students or makes an offer, then it is a direct communication. In direct communication, there is no gap between speaking and hearing. So, telephonic conversation is taken to be a direct communication even though there is no physical presence. Whereas in direct communication, whereas in indirect communication, communication is not by physical appearance but by a third person. Example, by post, as there is a third party involved like the postal department, there is a time gap. Now, another thing that needs to be taken into consideration is that, for example, if a person makes an offer to another person B, now this person A is standing on the first floor and this person B is standing on the ground floor. He shouts the offer. However, that offer is not reached to the person B who is standing on the ground floor because of the slogans shouted by the people on the ground floor. This is not a valid offer because words must be clearly heard. So now we move on to acceptance and communication of acceptance. Now the parties must understand the terms and conditions of the contract. There has to be consensus at item. There has to be meeting of minds. So there has to be acceptance of the offer and it has to be a free consent. That has to have a free acceptance. So to ensure meeting of minds, it is necessary that it must be communicated. Now, when the communication of acceptance is complete, the contract comes into existence and it is binding on both the parties concerned. That means offer when accepted becomes a promise and promise when supported by consideration amounts to an agreement. Now section 10 is very relevant in this because to elevate the agreement to a status of a contract, we have to see that section 10 is adhered to. Conditions, basic requirements that are mentioned in section 10 are very well adhered to. So section 10 talks about that an agreement will become a contract only when it is through a free consent and the parties are competent to contract. It is for a lawful consideration. It's with a lawful object and not has been hereby expressly declared to be void. So parties must be competent to contract. He must be major. Person must not be of unsound mind. Person must not be expressly disqualified by any law to enter into a contract. Consent must be free. Consideration and object of the agreement must be lawful. So agreement must not be of a kind which have been declared by any law as expressly void. Even in the Indian Contract Act section 24 to 30 are such agreements which are void. For example, restraint of marriage. Now, the contract must be fulfilled, honored, otherwise, in case of default, the defaulting party is liable to pay damages. There is a remedy available. Now, there has to be an actual performance of contract, failing which there is a remedy available. Damages rewarded can never be more than the actual damages. Now, one important thing which I'm going to tell you here is that for general principles are there in the Indian Contract Act. So it must be complied with. However, if there is any specific legislation that is applicable to a contract and there are certain provisions mentioned which makes it important to be applicable on that contract, then the provisions mentioned on the Indian Contract Act and that specific legislation must be both adhered to. For example, in case of property purchase and sale. So as per the Transfer of Property Act or the Indian Registration Act, the Registration Act, it is important that the purchase and land agreement of the property must be in writing. So therefore, the provisions of the specific legislation and the Indian Contract Act must be both adhered to. However, the Indian Contract Act does not provide for any requirement that the contract must be in writing. An oral contract is a perfectly valid contract. With this, I conclude here and I would be moving on to a detailed discussion on offer in the next lecture. Thank you.